your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, professionals, employers, and licensed immigration attorneys engage, learn, and stay informed on the latest developments in U.S. immigration. My name is Shelton Prince, and I'll be your host for today's session. It's around green cards in 2026, EB-1, EB-2 NIW, PERM, what's changing, and how to improve approval chances. Employment-based green cards are entering a more competitive and closely scrutinized phase in 2026. From evolving adjudication standards to shifting policy priorities, applicants pursuing EB-1, EB-2, national interest waivers, and PERM-based green cards are facing high expectations and far less room for error. Understanding how cases are reviewed today is critical for professionals, entrepreneurs, and employees planning long-term immigration strategies. To guide us through this critical discussion, we are joined by attorney Ingrid Perez. She brings personal and professional insight to employment-based immigration, both as immigrants herself and through her work with professionals and business navigating the U.S. immigration system. Fluent in English, Portuguese, and Spanish, she focuses on EB-1A, EB-2 NIWs, 01 visas, and employment-based filing for global talent. Attorney Perez, thank you so much for joining us again today.
Thank you so much for having me.
Before we begin, a quick reminder, immigrationquestion.com is not a law firm. This platform serves as a public meeting ground where individuals can learn about immigration topics and engage with licensed attorneys who participate independently. To everyone tuning in from Facebook, YouTube, LinkedIn, and other platforms, welcome. If you haven't subscribed yet, now is a great time. Go ahead and hit that subscribe button, grab your notepads, and let's get started. Attorney Perez, as we move into 2026, what major policy or adjudication shifts are you seeing across EB-1, EB-2 NIW, and PERM cases that applicants should understand early?
That's a really great question, and I think a great way to start. I think the broadest trend that we're seeing is increased scrutiny across these very employment-based filings. USCIS is applying definitely a heightened scrutiny to the evidence in the petition that you submit, definitely applying higher scrutiny to the narratives as well across your EB-1A or EB-2 NIW petition. They're demanding more robust documentation and a lot clearer connection between your achievements and the criteria that you are claiming, right? So that is specifically or especially true in EB-1As. It's also very much true in EB-2 national interest waiver. In EB-2 national interest waiver, adjudication has been tightening. We had a policy manual update from January 2025 of this year that clarified a lot of how USCIS approaches these cases and how petitioners can present a case, right? So officers now are evaluating your professional eligibility a lot more closely. They are also scrutinizing a lot more claims to national importance of a particular endeavor. And I think the evidentiary demands for NIWs have also increased. There has also been a rising denial rate and just a lot more demand for granular evidence. NIW denials have definitely outpaced EB-1As. We're seeing a lot more denials in national interest waiver cases. So I think this is showing a significant shift in adjudication. But I also think that is going to force people to really self-select, right, when it comes to applying for NIWs, because I think most people want to apply for these cases to win. So definitely ensuring that people submit evidence of measurable impact and national scale benefits, right, is very important for the purposes of an NIW. And I think in the world of PERMs, labor certification, the Department of Labor is definitely being increasingly asking for more requests for information and audits to validate recruitment that's being done by employers. Instead of just automatic audits, I think that there's definitely a lot more specific audits in these kinds of cases. And I think it just shows the procedural tightening of these types of cases, with that agency.
All right, thank you so much.
Yeah.
For EB-2 national interest waiver petitions, the USCIS appears to be applying closer scrutiny. What specific elements of the proposed endeavor and national interest analysis are officers focusing on most right now?
That's a really great question. I think that what I have seen is USCIS demanding just a much more detailed description of the proposed endeavor with specific outcomes that shows, that essentially proves the national importance. So it's not enough to say that something has national importance. You have to prove it. Typically, that involves submitting additional documentation that can corroborate your claim of national importance. But I think USCIS wants you to take your importance, your national importance argument one step further by submitting direct evidence. So it's not enough to say that your endeavor will lead to improved manufacturing processes. I think it's really important to back that up with examples. And of course, there's different ways of doing that for sure. I think another way also is clarifying your profession and that connection to your endeavor. You have to show that your occupation really qualifies as a profession. You have to show that your post-bachelor experience is in a specialty, or related whenever possible. That's also very important. And I think also there is just a lot more scrutiny in officers assessing whether the benefit you are bringing about to the United States really elevates the United States national interest, right? Beyond just general economic or workforce benefits. Broad claims are no longer okay. You have to make a much more specific showing of national interest and a connection. How does your specific endeavor specifically addresses that important strategic interest for the United States, right? And also showing that you are well positioned. And I think this is something that, particularly for petitioners outside of the United States, filing NIWs, showing that you are well positioned with either resources if you're coming to the United States to, and your endeavor involves opening up a business perhaps, or if your endeavor involves research or whatnot, right? Showing that there is an interest in the United States for your work, that really is important, I think, to show that you are well positioned. So those are just some of the areas that I see that I think is really important to focus in for 2026.
All right, very interesting. Thank you so much for that. Next question is in EB-1's extraordinary ability cases. So how is the USCIS currently interpreting sustained national or international acclaim? And what types of documentations are proving most persuasive in recent decisions?
Yeah. So for this particular question, whether or not somebody has sustained that national or international acclaim, it's really important to look at the case as a whole and not
Mhm.
just isolated achievements. And that's
Okay.
why I think it's so important for people when they're considering filing EB-1As, not look at each criteria like a laundry list. I think
Hmm.
the story has to make sense because you want to show that you really have reached the very top of your field, that you are
Yeah.
recognized as that expert, that go-to person, in your very niche field. So I think that's very important. So I've been advising a lot of my clients to consider not submitting certain criteria because I think
Yeah.
it hurts the story rather than elevate it, right?
Hmm.
You don't need to hit every single criteria for an EB1A. I think it's just
Hmm.
very important to know when and how to edit a petition to tell that compelling, persuasive story of how you reach the very top of your field. And also another thing that's very important to keep in mind is that there is that two-step adjudication, right? Immigration is looking at whether or not, sure, does your evidence meet the minimum requirements for the regulation? Whether
Yeah.
that is weak evidence or strong evidence, do you meet the minimum requirement for that criteria? And then it looks at the case as a whole through the final merits to decide whether or not based on the evidence, based on the totality of the evidence that you submitted, including evidence that maybe does not support a certain criteria, have you sustained that a claim? Have you met that totality standard that USCIS is looking for? So that's why I think editing is so important and knowing when to maybe hold back, and you don't necessarily need to include every single accolade that you have achieved in order to support an EB1A petition. So I think the things that USCIS is looking for is high impact scholarly work. If you're claiming that criteria, definitely
Okay.
show that this is a journal of high impact, that is selective, that only wants the best of the best. Major media coverage, for example, if this is something that you're going to use, to make sure that actually it is major media and not just, a blog or something that just is doing a profile, a piece about you. Those tend to hurt more than help. um if you are again showing awards, right, does it make sense? Are you in a type of profession where you are receiving awards? I work with a lot of people in technology. These are people usually behind the scenes. They're not
Hmm.
the front facing, they're not the front facing person at the
Yeah.
company. They're not necessarily getting that public credit. So
Hmm.
sometimes including evidence of awards may not make sense for that specific professional, for that specific story. So looking at every document that you intend to submit and making sure that they meet the language of the criteria, right? And knowing how to use expert testimonials
Hmm.
strategically to support certain claims, right? So expert testimonials, I think I like to use them a lot to support original contribution of major significance, that particular criteria. I think testimonials really help to contextualize the contribution and explain why it may be of major significance. And also, testimonials, I think, work great in showing that a particular role was critical or leading in a
Okay.
particular organization, which I think is one that a lot of professionals are able to get if they are able to use those expert testimonials strategically.
Very interesting. Thank you so much for that.
Yeah.
So, I mean, the next question, so PERM remains a long and complex process, right? So, like, what common employer or applicant missteps are most likely to lead to audits, denials, or extended delays under current Department of Labor and USCIS practices?
Yeah. So I completely agree that
Mm.
PERM is one of those things where I think it's very much forward looking and backward looking.
Mhm.
Whenever we start a PERM case, we have to think a year out, a year and a half out. How is this prevailing wage going to look like in the 9089 application? How is everything going to look at ultimately at the very end when we're filing the petition? So I
Okay.
think the first one of the first big missteps is inconsistencies, right?
Mhm.
Mismatching between the prevailing wage and the labor certification, mismatching with the job description and the job details, the titles, the duties, the wage levels, etc. These things often trigger audits or requests for additional information. Also, overly restrictive or unusual requirements, I think, is one that triggers a lot of these as well. It's
Okay.
very important for the perm process that we describe, that we create that job in the minimum, in with minimal restrictive
Mm-hmm.
language. The requirements really have to be the minimum for that position that you're looking to fill.
Mm-hmm.
I think, of course, another area that a lot of people get tripped up on is with the recruitment. Right? Recruitment is very important because perm is a good faith process. So
Okay.
improper advertising or incorrect, notice posting dates, or not keeping track of the people do apply for the position and not making sure that you're documenting all of that can
Mm-hmm.
definitely come back to haunt you later down the road if there's scrutiny. And I think also some beneficiary related risks, right? If, for example, an employer is using the beneficiary's work experience or the
Okay.
experience that they gained while working for the employer,
Mm-hmm.
it doesn't necessarily mean that it can't work, but that's something that's very important to know ahead of time and know how to navigate that.
Okay.
You want to make sure that you are not tailoring the job just for that specific employee. It's also very important to know that if the employer is going to be requiring certain things out of the job, like for example, a foreign language or perhaps a lot of travel requirements, those things can also look suspicious to the Department of Labor and can certainly trigger an audit.
Interesting. Thank you so much for that.
Yeah.
For professionals who may qualify under multiple employment-based categories, yeah, how should applicants think strategically about choosing between, EB-1, EB-2 NIWs, and PERM in 2026?
Yeah. So the first thing that I would say off the bat is that if you have an employer willing to file a perm for you, please
Hmm.
go for it.
Yeah.
It's still a very viable path. And if done right, it will get your priority date, right? If you have an approved
Makes sense.
petition through a perm process, you're going to get your place in line. So if you have an employer who's willing to do it, please let
Okay.
them do it. It is definitely an option. And then, of course, when you're thinking about EB-1A or EB-2 national interest waiver, I think it's very important for people to understand that these are not things that you're picking up off a menu, right? You really
Yeah.
have to understand whether or not you qualify for the benefit that you're seeking. I think
Hmm.
there are quite a few people that can maybe go for both. Right. And
Okay.
if it makes sense for that individual, they may want to go for an EB-1A and an EB-2 NIW concurrently to see which
Okay.
one sticks. Right. For a
Okay.
lot of people, though, what I tell them is listen, and I do this a lot for my clients who are researchers, because I think researchers oftentimes have a great profile for an NIW.
Hmm.
We go about it strategically, especially given, some people, if you're born in India, for example, you're facing extreme backlogs, right? So there is a strategic purpose of maybe getting an EB-2 national interest waiver priority date set locked in, because you can always work towards an EB-1A later on
Okay.
and you're going to retain that priority date. So I think understanding what is the ultimate goal, which category of visa best fits that person, right? What is your risk tolerance? Do you want to just really go for it, knowing that maybe you don't have a good shot at it? I don't personally like that approach because I like to feel good. I like to feel like I can win the case. I want to believe in the
Yeah.
case.
Yeah.
But that is an approach that some people may choose to take. I think ultimately at the end of the day, people are looking for approvals. This is a
Okay.
huge investment of time and money on their part, right?
Hmm.
So
Yeah.
EB-1A for sure are for those top performers,
Okay.
highly accomplished professionals with clear and significant acclaim. I think that's very important to know. If you have a so-so EB-1A, I think that you may not want to go for it yet.
Hmm.
If you're working in, an area that is nationally important and you have an endeavor that will advance the United States strategic interests, and maybe a national interest waiver might be better for you, right? Not everybody
Okay.
can qualify for an NIW just because they have a degree, right?
Yeah.
You have to think about whether or not an NIW makes sense for your case as well, right? Because there's also like for example, in for tech professionals, right? I have a lot of clients who are great candidates for EB-1A, but they are not great candidates for EB-2 national interest waiver because the requirements are completely different.
Makes
So,
sense.
those are just some things to keep in mind. And I think it's very important to have an individualized approach and
Okay.
a comprehensive understanding of all these different options, so that you can sort of navigate through it all and know what is what and what your employer is doing for you and what you can do for yourself.
Oh, perfect. Makes sense. Attorney Perez, thank you so much for that. So looking ahead, like what practical steps can applicants take now before filing to strengthen their profiles, their documentation, and overall case presentation?
So I think the first thing that a person can definitely benefit from is talking to an attorney to sort of understand where they are headed, right? Does it make sense to pursue an EB-1, or does it make sense to pursue an EB-2 national interest waiver? I find that a lot of clients who are pursuing these options are very knowledgeable about these types of visas. They read a lot about it. They
Mhm.
understand. They have a very, a good solid understanding. So I think
Okay.
that's really important, starting with that foundation, but then understanding how those things may apply to your particular situation. Once you are sort of set in on where you are going with this, I think gathering your evidence and starting your evidence mapping is very important. I talk to a lot of people who are considering EB-2 national interest waivers, and they
Okay.
may have a really good case, but they don't have evidence to show for it because they
Okay.
don't know necessarily what they should be collecting throughout their career, right? They may have a lot
Okay.
of experience, or a lot of achievements, but these achievements are just tied to their employer, right?
Okay.
And maybe they
Yeah.
do things outside of the employer as well. Maybe there are collaborations that could be used, or different experiences and achievements that can be used for the purposes of an NIW. But by the time we talk, maybe they don't have contact, or they lost the contact, or maybe they can't find the document or whatnot. So having that mindset of creating a detailed evidence map, linking your documentation, saving your documentation, even if you're not going to use it later on down the road, I think is just really important to start doing early on. And also making those connections with people in the industry who can later become your recommenders, people who can support your petition, that can speak to your skills and your
Mhm.
achievements and your contributions and your impact. I think that's also really important. Documenting your quantifiable incomes, your quantifiable outcome. I always say that immigration is about, or these petitions is about showing, not telling. We really need to document it with quantifiable information, or explain it with quantifiable information and document it with corroborating evidence.
Yeah.
So those are sort of my tips, right,
Okay.
to help people strengthen their case. And I think also give yourself a deadline and think about when you want to file, get
Yeah.
yourself ready, and understand that once you make that commitment to work with an attorney, or whatnot, it's a lot of work. You have to be
Yeah.
ready to put in the work
Yeah.
for it, for sure.
Makes so much sense. Attorney Perez, thank you so much for all of that valuable insight. So yeah, I think just to everyone joining us live, thank you for being part of this vital conversation. Employment-based green card filings require careful planning, strong documentation, and a clear understanding of how eligibility is evaluated. So staying informed can really make a meaningful difference. If this is your first time tuning in, welcome. Immigrationquestion.com is a networking platform where professionals and families can ask immigration-related questions for free and engage directly with licensed attorneys. Some users may also be eligible for a private discussion with a participating attorney. We are also proud to share that immigrationquestion.com is a triple B accredited, reflecting our commitment to transparency, accountability, and community education. Attorney Perez, so I mean, based on your experience, how do you see a platform like immigrationquestion.com helping applicants prepare more thoughtfully for employment-based green card filings in 2026?
Knowledge is power. When it comes to immigration, knowledge is power. I
Yeah.
think that when our clients are knowledgeable about the process, they don't have to be experts, but I think when they are knowledgeable, they have the insight, they work better with their attorneys, they work better, with planning their future and their visa strategy. So I think anything that offers people out there credible knowledge from credible sources, because credible
Hmm.
sources is very important as well, I
Yeah.
think is very important and very useful.
Very interesting. Thank you, Attorney Perez, and once again, just thank you for all of that insight. So, before we move into our live Q&A, I think I got one final question for you. So, for professionals and employees, or employers rather, planning to file in 2026, what immediate steps would you recommend taking right now to avoid common pitfalls?
I think understanding where the employees are with their
Hmm.
visas, expiration dates, deadlines, budgeting, all of that is really important because immigration doesn't work on our timeline. We have to
Okay.
work around immigration. So I think, if you're getting ready to file, getting all your ducks in a row, making sure that you know when an EAD is going to expire, when an extension is coming to an end, who needs to travel abroad to get stamped, who doesn't, family members, account for all of that, right? Is good to create an inventory of all of that information so you can plan ahead.
Mhm. Okay. Thank you so much. And
Yeah.
I think if you've, to everyone else listening, if you've just joined us, we've been speaking to attorney Ingrid Perez on green cards in 2026, relatively speaking about EB-1, EB-2, and NIWs and PERMs, and specifically around what's changing and how to improve our approval chances. So we're now going to be moving into our live Q&A session. So this is an opportunity for you to ask questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483, and we'll take as many questions as possible. So this question we've got here is from Maya Akbula. Her question is, I heard EB-1 priority date is now moving fast. Is it true, and why?
Well, the visa bulletin tells us how many visas, or they tell us where you are in line, right?
Mhm.
We did see some forward movement for the upcoming January 2026 visa bulletin, and it's all about supply and demand.
Yeah.
When the demand becomes less, the visa priority, the priority dates definitely move forward. So that's why, right? Is it true? Yeah, it's true for this month, right? It doesn't mean that necessarily February we're going to see the same movement. We've seen visa, the visa bulletin priority dates retrogress. We don't want that to happen, right?
Mhm.
But we certainly saw that, I think, for January 2026.
Interesting. Thank you so much for that. So the next question we've got here. So this question we've got here is from Hannah Latta. So for EB-2 NIWs, do I still need a job offer or can I self-petition?
You can self-petition. National interest waiver or NIW stands for national interest waiver. We are
Okay.
waiving the requirement of a job offer and a labor certification. So you can certainly self-petition.
All right, perfect. Next question we've got here. The next question we've got here is from Elena Rodriguez, and the question is, how long after PERM approvals will the person have their green card interview or get an approval?
It depends. I know it's not a satisfying answer, but after the PERM approval is when we begin the petition filing, which is the Form I-140 with USCIS. That Form I-140 will identify the category of visa that the
Mhm.
petitioner is looking for, whether it's an EB-2 or an EB-3. That will also, have an impact on when the person will get the interview for the green card. So after the petition is approved and when the person's priority date becomes current, the priority date is a date that we filed the perm. Then we're waiting for that priority date to become current before the person can file for the green card. And now the interview is a whole other can of worms. It very much depends on visa availability,
Yeah.
workforce, all of that. So, it could take some time. It could take some time. Maybe a year or two. I don't know, but it's not going to be. It's not going to be quick.
Okay. The next question we got here is from Nikhila McKenzie, and the question is, what is the strongest proof for EB-1 extraordinary ability? Which awards and publications matter most?
Well, I think that a right answer doesn't exist here. It all depends on whether or not the award matches the requirements of the regulation. So if you have a Nobel Peace Prize, maybe an Olympic medal, an Oscar, right?
Yep.
That's a great award, and you can get an EB-1A visa just based on that award itself. But if you don't have that one, lifetime achievement award that USCIS considers good enough for the EB-1A
Mhm.
by itself, then you have to go with 3 out of the 10 criteria. And I would say awards or publication, which one matter most? Well, they all matter if you're going for both of these, right? It's about figuring out if the award or the publication meets the requirements of that specific criteria. I would say for researchers, right, publications are really important. Awards can also be really important if maybe you won best research paper, if it's from a very prestigious organization, you won that award for excellence in your research. Both
Mhm.
are very important. So I would say it just really depends. It depends on your professional profile, and how you are presenting your case.
Okay, interesting. The next question we've got here is from Bartholomew Cuba. And the question is, can a patent or product I made help my EB-2 NIW application better than having many publications?
So you got to understand, I guess, we'd have to decide how we're going to be using this patent or how you'd be using publications.
Mhm.
Um, a patent is great evidence, I think, of an invention, an original contribution, right? And then has your patent been assigned? Has it been used? Has it been cited? Right? It's not enough to just have a patent. You do have to show that that patent has some impact, some potential.
Okay.
So publications, right, show that you are sharing your knowledge. If you
Yeah.
get citations, if you're cited for your work, that is also very good because it shows influence, it shows broader impact of of your skills, your expertise. So of course it just kind of all depends, right?
Mhm.
Many publications, I think, in low impact or questionable journals will weaken your case, whereas a few publications in very high impact selective journals, I think, will help even if the citation count is not a lot, right?
Okay.
Yeah.
Thank you, Cindy Perez. I think we've got one final question. The question is from Ashia. And the question is, do big companies have better success for EB-1 and PERM than smaller companies?
To be quite honest, I don't know. I just don't know what the success ratio is. I think it depends, right? For bigger companies, I would think like a Microsoft or Facebook or Meta or things like that. They just have much bigger perm programs. A lot of these professions are software engineering, and these technical jobs, which I think a lot of people want to work at a Meta or a Microsoft as a software engineer. So they, maybe the success rate is not that high because you get a lot of actually qualified applicants, whereas a small company, maybe an applicant will not respond to that recruitment ad because they don't want to perhaps work at a smaller company. So I think it just kind of depends. It's all relative.
Thank you so much, Attorney Perez. I think that wraps up our Q&A session. So I just want to move back into focus on a news bite section. So, Attorney Perez, so a federal judge has signaled support for the Trump administration's authority to impose a $100,000 fee on H-1B visas. So how should employers and foreign professionals interpret this development mean for future employment-based filings?
Well, I think until we have a decision from the Supreme Court, it's important to sort of take a deep breath and step back. If, however, the Supreme Court does allow this to move forward, I think it will be significant for the world of H-1B. It will force a lot of employers to, not hire H-1B workers and not go through that process, especially for individuals who are outside of the United States. People who are inside of the United States looking to change their status, they can still pursue the H-1B route. They may not be subject to the $100,000 fee, but people will be stuck here in the United States because if they need to leave, travel, get stamped for the H-1B, I think that's when the $100,000 fee would trigger. So I think it just puts people in a really tough spot, having to decide about, between building your life here in the United States versus visiting your family abroad. It's just, it's really difficult, difficult choice to make, for sure.
Okay. All right. Thank you so much, Attorney Perez. And just thank you for sharing your perspective and practical guidance today. Your insights help applicants better understand how to approach EB-1, EB-2 NIWs and PERM filings with clarity and preparation. And then to everyone watching, thank you for joining today's webinar. We hope this session helps you feel more informed and prepared as you plan your employment-based immigration journey. Remember, you can always visit immigrationquestion.com to ask immigration-related questions for free and engage with licensed attorneys. If you would like to revisit today's discussion or share it with others, the full replay will be available on Spotify soon. Just search for Borderless Talk by immigrationquestion.com. So join us again next week for another live session covering green cards, asylum updates, and family immigration developments. So thank you again, Attorney Perez, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay connected. Cheers, everybody. Bye.
Bye.